Can you negotiate estate recovery claims? If you are concerned about estate recovery claims after a loved one has passed away, you are not alone. Many families face this issue when dealing with Medicaid. Understanding your options can help ease some of that stress. Yes, it is sometimes possible to negotiate Medicaid estate recovery claims. This process varies by state and depends on specific circumstances. Medicaid estate recovery occurs when a state seeks reimbursement for benefits paid on behalf of a deceased beneficiary. This usually happens after the beneficiary's death and involves recovering costs from assets that go through probate, or in some states, from non-probate assets as well. There are key points to consider when thinking about negotiating these claims. First, some states allow exceptions or waivers that can reduce or even eliminate the estate recovery claim. For example, if there is a surviving spouse, a child under 21 years old, or a child who is blind or permanently disabled, these situations may qualify for a waiver. Additionally, if an unmarried adult child lived in the home full-time for at least 1 year before the Medicaid recipient's death, that may also help. Another important aspect is the negotiation of the claim amount itself. The estate's representative or attorney can sometimes negotiate with the state Medicaid agency to lower the claim amount. Deductions might include reasonable expenses related to home maintenance, such as real estate taxes, utilities, and necessary repairs. If the estate can provide receipts or documentation for these expenses, it can strengthen the case for negotiation. It is also essential to remember that rules and policies differ from state to state. Some states strictly recover only from probate assets, while others may include non-probate assets like certain trusts or jointly held property. The timing and conditions for placing liens on property can also vary, so it is crucial to be aware of your state's specific regulations. In some cases, federal law requires states to defer estate recovery if a surviving spouse or certain dependent children are living. Some states even offer hardship waivers that exempt heirs from recovery if it would cause significant financial difficulty. When a Medicaid estate recovery claim is filed, the estate representative should take specific steps. First, review the claim carefully and gather documentation of allowable expenses. Next, contact the Medicaid agency or estate recovery program to inquire about possible waivers or reductions. Consulting an elder law or estate planning attorney who is experienced in Medicaid planning and estate recovery can be very helpful. They can assist with negotiations and protect the interests of the heirs. While Medicaid estate recovery claims are a legal obligation, there is often room for negotiation or waiver. Understanding the specific rules in your state and working with knowledgeable legal counsel can make a difference in how these claims are handled.